Good afternoon. Welcome back to our Technology and Access to Justice lecture series. The series are hosted virtually here at the Legal Innovation Laboratory at the Faculty of Law of the University of New Brunswick, and we recognize and respectfully acknowledge that UNB Law gathers on the unsurrendered and unceded traditional lands of Wolastoqey. It is my great pleasure to introduce today's speakers, Professor Amy Salyzyn from the Faculty of Law of the University of Ottawa, and Professor Jacquelyn Burkell from the Faculty of Information and Media Studies at the University of Western Ontario. Both our speakers are leading experts in the broader technology and access to justice space. Professor Salyzyn has written extensively in the area of legal ethics, lawyer regulation, the use of technology in the delivery of legal services, and access to justice. And among others, Professor Salyzyn is involved in a multi-year project sponsored by the Ontario Ministry of Research and Innovation, studying and suggesting concrete ways in which the technology can be used to facilitate more effective access to justice for Ontarians. Professor Burkell, currently Associate Vice President Research at the University of Western Ontario, is involved in projects examining technology in the context of justice. Professor Burkell's research focuses on the empirical study of the interaction between people and technology, with a particular emphasis on the role of cognition in such interactions. Specific aspects of this research include the impact of presentation on information use and understanding, the implications of computer mediation for privacy attitudes, values, and practices, and the impact of technological mediation on communication and relationships. This leads us to the work that our speakers are presenting today, which is their empirical study about accessibility improvements that can result from online guided court form pathways. I will post a link to their study in the chat in a little bit. Amy, Jackie, thank you very much for agreeing to present and discuss your work here with us. You have approximately 40 minutes for the presentation, and we will be back with the Q&A. The floor is yours.
Excellent. Thank you so much. So I'm going to start and then hand it over to Amy when we get to the hard part. Really pleased to be here. Thank you so much for inviting us, and really pleased to talk about this work, which grew out of, Amy and I were part of for a long time, still are as it's closing up, a couple of projects that were looking at technology in the court system, and then specifically at AI in the court system. And as Amy's coming at this issue as a legal scholar, and I'm coming at this issue as a cognitive psychologist and a scholar of information. We got to talking one day, because I live with a lawyer. So a lawyer does family law, and I'm well aware of the real challenges that are associated with the use of interaction with court forms. And I'm also well aware of the problem, as a non-lawyer, the problem of self-represented litigants. And so we started talking about how there were ways of thinking about information, about documents, about our ability to interact with them that help to provide some guidance in how we can make forms in particular that are more accessible, easier for people to fill out, more meaningful for them, and that these would be interesting strategies to try. So the focus of the presentation today is a study that we conducted together with two law students, which involved the online guided pathways for family law forms provided to the public by the Community Legal Education Ontario, or CLEO for short. The paper, to which you're going to get a link, describing the study and the results, is now available open access on the University of Ottawa website, and it's going to be published in an upcoming volume of the Canadian Journal of Law and Society, which is in a special issue on person-centered justice. You can go to the next one, Amy. So the project was funded by the Law Foundation of Ontario, to whom we're very grateful for providing this support. So if we move on, thinking about this project addresses the issue of accessibility. And so I want to provide a little bit of background when we talk about accessibility. What do we mean? And accessibility is a really broad concept. It encompasses all kinds of different issues, including things like cultural accessibility, financial accessibility, accessibility in terms of web design. Can I actually load the page? Do I have the technology to do that? But we're focused on accessibility in a particular context, in the design of court forms. And really, we're focused on the kind of accessibility that has to do with literacy. It's the ability of people to interact and interact successfully with forms in order to use them in the way that they're intended, to provide the information that those forms are intended to gather. So we have to struggle with the question, well, how do you measure what makes court forms difficult to use or easy to use? What framework can you use to help understand what interventions might help? So the lens that we brought to this is a lens of functional literacy. We're going to talk a little bit about what that is later, because it's a very core concept in what we're talking about here. And we're talking about a particular problem, court form accessibility, and one avenue of intervention, that is the design of the forms. This isn't meant to preclude or replace any other discussions about accessibility. We by no means think this is the only version of accessibility, the only kind of accessibility we need to be considered with, but this is one kind that we consider to be important, just one perspective or one technique. Okay, so Kami, can you move on to the next slide, actually? So what inspired this project is the reality that in our justice system, we have a large number, and I understand an increasing number, of self-represented litigants. So these are people who come to the court system with a problem. They're not trained lawyers. They don't have the background, the training, the experience that a lawyer enters the courtroom with, but nonetheless, they come into the court system with many similar responsibilities. The McFarland studies, the first that was probably the first to take a comprehensive look into this in Canada in 2013, confirmed that an extraordinary, and that's their term, number of individuals were at the time self-represented in Canadian courts, with about 40% or more of litigants appearing in family court without counsel, and 70% of litigants appearing without lawyers in lower level civil courts. That same study also confirmed that what many had suspected, that the most common reason for self-representation is the inability to afford the services of a lawyer. So for the most part, people who don't have lawyers aren't choosing to forego counsel. It's simply something, having counsel, that is inaccessible to them. Go to the next slide. Okay, so we know from studies that self-represented litigants face numerous challenges. Court forms are often a main source of the frustrations and problems. So on this slide, you can see various quotes from self-represented litigants who were interviewed in the McFarland study. And you'll see that these quotes reflect that they're struggling. So the fifth time I did the first form, I was able to file it. Obviously, times 1 through 4 were unsuccessful, and one wonders why. Or the forms you're given out to fill out are extremely difficult to understand. They're designed for lawyers to fill out and not regular people. Absolutely true. I think there's a criticism that we recognize as absolutely accurate. Can't fill out the form, no one wants to help. And there's lots and lots of similar quotes that you can find about people having challenges, difficulties, interacting with these fundamental mechanisms, these mechanisms that are fundamental to the court process. So if we look beyond making legal proceedings frustrating and unpleasant, overly complex court forms can have devastating consequences for self-represented litigants. The judge said that she saw no safety issues preventing me seeing my son, but that I'd filled out the wrong application, so she made no order. I'd lost, not because of what I said about my son, but because of a technical thing about the law. This is a person who was doing their best to interact with court forms that they didn't, in a context they didn't entirely understand. And the consequences were serious, and the consequences were, at the very least, difficult to remediate, if not permanent. Individuals who are not lawyers interacting with these forms and interacting with the justice system as self-represented litigants might not be able to properly advance or defend their legal rights. They might even give up pursuing a case because they're just overwhelmed. So we can see that these forms, which are the way of interacting with the court system, or at least one critical way, are really important, and the ability of self-represented litigants to interact with these forms is also critically important. So if we can move on to the next slide. So now we come to the idea of accessibility and user-centered design. So I think you will probably all heard, we certainly have a concept of literacy. Our ability to understand usually focuses on people's ability to read and to write, to understand language. Functional literacy is a broader approach. And what functional literacy does is it takes as its focus, a task. What is a thing that people need to do? And takes as its focus a task that involves interaction with a form, typically. So I recently had to renew my passport. And in order to renew my passport, I had to navigate a website. I had to identify a form. I had to download the form. I had to interpret the form. I had to fill out the fields in the form. And if I did it wrong, as I almost did, I wasn't going to get my new passport. So it turns out that if you think about we typically think about literacy as a quality that rests with an individual. So a person is literate or is not literate. And we have interventions that can improve people's literacy levels. We teach them to read better, or we teach them to write better. But there's another way of thinking about literacy, which is the functional literacy approach, which is to say, why does literacy matter? Well, literacy matters because it's a thing that you need to do. And that thing that you need to do, that task, always occurs in a context. Well, typically occurs in a context, an information context, a context of a system, a context of, in our case, we're focused on documents. So what if we thought about literacy as encompassing the whole, the person trying to do the task and the things that they're interacting with? And what if we thought, instead of fixing the person or only fixing the person, why don't we also try to fix the documents? So let's think about ways to make documents more supportive of the task that needs to be achieved. It's like turning the problem on its head, saying it's not a problem with the person, or it's not only a problem with the person, it's a problem with the document. And I can give you an example from the language context. I can write a really long sentence with really many subjunctive clauses and long words, and academics are really good at doing this. And if someone doesn't understand it, I can say, well, that's their problem. But I could also work to write the sentence in a way that is understandable. And again, as academics, we're not really very good at doing this most of the time. But why don't I do the work in writing the sentence instead of and fix my sentence, instead of having the person who's trying to understand it fix their capacity to understand? And at the very least, let's treat this as a joint task. Let's not center all of the challenges with the individual. And that's the approach that we're taking in the study. We're saying we've got court forms. We know people are having difficulty interacting with them. What could be done systematically in order to improve those court forms? And what does a functional literacy framework tell us about the kinds of problems that those court forms will present? Okay, so there are lots of examples sorry, I'm going to spend a little bit more time on this previous slide. There are lots of examples of the kinds of ways in which documents can be improved. And the functional literacy, the literature on functional literacy actually provides some really good guidance on these. And it's pretty simple things a lot of the times. It's like, if you have a form that refers multiple times to a person's last name, you really should be using the same term to refer to that name the whole way through. Don't call it last name at one point and surname at another point. Even though sometimes when we want to get fancy in the way that we write, we do that. We say, oh, use your last name. Next time, use your surname, because I don't want to repeat myself. Repeating yourself is a really good thing from a functional literacy perspective. Pick one category name and use it. Using design elements to highlight, using textual white space and font elements to highlight places in the text where interaction or input is required, is a design element that you can easily do that makes it easier to interact with the form. And if you don't do it, it makes it harder to interact with the form. So we rely really heavily on a functional literacy approach that has a structured way of assessing documents and a structured way of identifying the places in which documents or the ways in which documents are less than perfectly amenable to the task that they want to be, that they want to support. Okay, so the background to this specific study, we had carried out 2 previous studies of paper-based court forms in 2016 and 2019 using functional literacy concepts to gather both quantitative and qualitative information about what specifically was making those forms difficult. So one study involved using a functional literacy framework to assess the complexity levels of all the different fields that people needed to fill out on the court form. So we applied this structured analysis to it. And this isn't just to give a document a score to say it's a hard document or an easy document, but instead, and perhaps most importantly, to say, oh, here's the places where that particular document has gone wrong. So we use that structured approach to assess the documents. And then we later on said we did a human studies where we had people going through the forms. These were people who, they're not litigants, not self-represented litigants, exactly issues associated with that. But we asked people to think themselves into a scenario where they were filling out this form. We gave them a context, a story to think about it, and said, go through the form and try and fill it out. And we observed where they had difficulty, where they struggled, and with the forms. And not surprisingly, they identified challenges that didn't come out of the functional literacy approach, but they also identified a number of challenges consistent with the issues that were identified in the functional literacy approach. So if you can, we can go to the next slide. So what are some of the issues that were identified in the functional literacy approach in our analysis? Well, using technical legal terms that are difficult to understand. Yeah, why not? In a medical context, don't talk about cardiac arrest or myocardial dysfunction. Talk about heart attack, because that's the term that people use. And maybe a physician, in this case, has a little bit of problem because technically there's a difference between the use of these terms, but understand that your audience is not technically using the terms. They're trying to figure out what they're going to do. And for them, a heart attack is a heart attack is a heart attack. In this context, it's all that matters. And the same thing would apply in the legal context. It's like, instead of picking a complicated term, a $10 word, use a $1 word, because it's always going to make things easier. Try not to use broad or unclear terms. We really saw that a lot of the time. The terms were very, very broad when a narrower term and closer definition could do. There were many situations in which what looked like a relatively simple thing was asked for in a form, but it required users to pull together multiple sources of information to complete a task. And when a user has to leave a form to go do 6 different things, to look at 6 different sources to complete the task, that's a functional literacy barrier. Let's make it simple for them. And then we found that the forms themselves were very complex in structure, and the accompanying guides didn't really help. And contextual assistance, like you're at line X, I think you get for your tax return, actually, you're at line X, here's guidance about line X, is really helpful. And actually, interestingly, when we get to the online forms, you can provide that kind of contextual assistance. It's not cheating to make things easy for people. And it's not even kind, it's effective, I think is our point. So on the next slide, we have just an example of the framework that we're using to quantitatively analyze the complexity of the task. This example is drawn from the divorce application form, which requires users to indicate whether the parties have arbitrated or agreed to arbitrate any matter involved in the case. Our quantitative study involved using this very specific analytic tool to evaluate how difficult we expect that task to be for users, and then to compare this with what we know about the average functional literacy levels in Canada, because we have data on that. So again, I want to emphasize that in our work on paper-based forms, we didn't stop with this quantitative analysis that said this task is difficult and has this degree of difficulty. But we paired it with a qualitative study that looked at the way users, admittedly in a hypothetical situation, were interacting with the form and what sorts of difficulties they were identifying. And I think if you go back just to that language in the beginning, indicating whether parties have arbitrated or agreed to arbitrate in any matter involved in the case. As a non-lawyer, I read that sentence and I go, there's a bunch of stuff in there I don't know what it means. I'm not sure what it means to arbitrate. Might be second nature to someone who's legally trained. It's not going to be second nature at all to someone who doesn't have that. And what is any matter involved in the case? What's the sphere there of things that are relevant? It's not made clear. And your self-represented litigant is trying to make sense of this given their worldview. So a functional literacy approach can potentially help researchers and form designers understand why a person reaches a certain part of the form and they have difficulty. Maybe they leave it at that point. And once you know where people are having problems and you have an understanding as to why people are having those problems, then you can look to intervene. Because just trying to intervene is not, without a framework, is not going to work. It's just not going to be helpful. So our study had, these previous projects had multiple recommendations, including moving away from paper-based court forms or flat PDFs, and instead using interactive digital forms that can provide tailored, detailed, and context-specific assistance to users. That's the real advantage of going to online forms. You can deliver just-in-time information. And this can address many of the things that we've noted above. You can have users just see what parts of the court forms they need, for example. That's pretty easy. You can eliminate the stuff they don't need, or you can have pop-up definitions that will allow them to flip back and forth between a guide and the form that they're using. Instead of having to open the guide here and kind of scroll through it, why not just be able to have them click a link and go to the relevant information? That's something that you can do, the relevant assistance. That's something you could do in an online form that you absolutely can't do with paper-based forms. And now we're to the point where we have our project with Clio, and I'm going to turn over to Amy, where we had the opportunity to look at people's interactions with online forms. And I'm going to mute myself.
Thanks so much. That was very interesting, and as always, and super helpful context to this project. So, I mean, this is to sum up generally, we did all this work on kind of PDF forms and paper forms and found these challenges. And in these papers we wrote, we made one of our recommendations and say, really would make sense to look at interactive digital court forms as one way of addressing some of these. And looking out in the space, we noticed that Clio, which is a community legal clinic in Ontario, actually was starting to provide these sorts of forms, which they call guided pathways to the public. And they started in a few different areas, including family law, and now have expanded to a number of different areas. And so in partnership with the Attorney General, they do provide these interactive, digitally based pathways to help people fill out court forms. And I don't know the recent numbers, but the usage is quite high in the family law area, talking about hundreds of people, at least in Ontario, a month using these forms. And so it's a great opportunity to test. We made this hypothesis that these guided law pathways could help people. And so it gave us an opportunity to try and test that. Do these pathways actually eliminate or mitigate some of these barriers we found? And we also wanted to think about, we talked about functional literacy, helping people make better paper-based or PDF court forms. Could they also help design these court forms better? And then, what might be some of the remaining challenges? And so those were the broad questions we were looking at in this project, and had a great partner in Clio with helping us explore these things. If you read the paper, you'll see our study had a variety of different parts. Before Jackie and I even got into anything, Clio undertook an initial project to look to improve their family law guided pathways based on a functional literacy approach. So using some of those techniques and frameworks to identify where might some of these tasks we've embedded in these guided pathways be complicated, can we make them easier, things like that, and use a multidisciplinary team, and went through that quite rigorously and did make a lot of changes to their forms. And so once we had the updated guided law pathways and those were live, we looked to gather human subject information. And so we did that in two ways. We were able to access anonymized information that were provided by the system when people were actually using the form. As we discovered, the system at that point was collecting, somewhat limited information, which then led, I think, Clio to look at more ways to collect information. But it was collecting information. We also included a survey in that, all anonymized, and so we kind of got hundreds of those data points populated to analyze. We also, similar to what we did in our previous studies, looked at having individuals without legal training go through hypotheticals using the guided pathways. I think we had about 4 different hypotheticals. They use both the guided pathways and then also the current PDF form that's also available to people on the Ministry of Attorney General website. We had 2 different sets of subjects going through either the PDF forms or the guided pathways. And so we look to see in these walkthroughs, observing passively, where are people finding the difficulties and why. The studies, the results of studies are fairly detailed. We have the conclusions here, but that paper kind of has all the information that supports these conclusions and may be interesting for some of you to read. Given the time we have, I'll highlight kind of 2 major categories of conclusions. And so we did feel like we were able to clearly conclude that, yes, our prior hypothesis was right. Online interactive digital court forms can reduce complexity, and that leads to not only an observation about these particular pathways, but maybe also guidance for other jurisdictions and other areas of court forms. Consider these as access enhancing measures. And I know, different jurisdictions are taking up this method to different degrees. And there was kind of 2 reasons, 2 kind of sources of improvement. Certainly we found one source of improvement was because this was digitized in the guided pathway form. We saw quite clearly one major advantage is allowing users only to have to see the parts of the form essentially that they need to answer. So you can imagine, I don't know how many people have seen family law court forms, but if you have a general type of application, it's going to deal with issues including if the people have children, all different types of financial situations. There may be somebody that has a situation where they don't have children. So there's aspects of that multi-page court form they don't even need to answer. And it can become quite confusing and overwhelming if they're presented with all that. If you have a guided pathway, it's a bit of a choose your own adventure. You answer right away, what's your situation? And you're only taken to those questions that you need to answer. And so it reduces a lot of that cognitive load on people and makes it a lot easier to fill out. Same with even remedies. So some of these court forms have big, long lists of technical remedies. Some of them may not be applicable, but the user might not easily understand that. Again, this allows it to target the questions to what's relevant to that user. Certainly, something Jackie mentioned before, the on-demand information is quite helpful. And so these guided pathways at various points have things like pop-up definitions in as plain language as possible. They also provide contextual information about why certain questions are being asked, and that can be quite helpful. So for example, I think one part of the form may talk about address for service, and people looking at that PDF, had a lot of confusion as to what address they should put there. The guided pathway explained, essentially we need to know where we can reach you if we need to give you documents, and that helped people understand, should it be their previous address, their current address, their work address? And those were real questions people have when they're walking through these court forms. And so that context can be quite helpful, and the guided pathway can help you with that. So all those things are facilitated by a digital format. You can't do that in that paper-based or PDF format. We also found there was kind of another set of benefits that really did stem from the fact that these guided pathways, take as their user non-legally trained people. And so again, plain languaging things in those pop-up definitions, that context, all that helps people quite a bit. And the kind of the traditional court forms are kind of really designed for justice system stakeholders, so lawyers, judges, court staff, and not necessarily for kind of one of the main users of these court forms, people who are unrepresented. So we did see and kind of see the detailed ways we establish evidence of those benefits in the paper. We did see those benefits quite clearly. We also wanted to explore, and we weren't surprised that these forms don't solve everything. Wouldn't it be great? But there were still remaining challenges that we saw. And there's kind of 3 that we highlighted in the report. One remaining area of challenge was open-ended prompts. And this is something that the functional literacy framework would identify, always as complex. It's much more difficult for people to provide an explanation for something than just kind of fill in a piece of information they have to locate. It's easier to fill in your own address than it is to say, why are you making this claim? And try and fill in a part of a court form that wants you to give that explanation. One thing the guided pathways do with some of these open-ended parts of the court form is do break down introduce new sub-questions for users that can kind of help people know what information might be relevant, elicit more of a detailed response. And so we found that was helpful because the people that were looking at the PDF forms, when they saw these big blanks, they really didn't know where to start necessarily very easily. But we still found even, with those sub-questions, people identified these areas as being challenging. They didn't know how much detail to include. Did they include the right things? And I think that's no surprise. We think about the situation that people are in when they're filling out court forms. You are providing quite, personalized, very detailed contextual information. And so even with sub-questions, it's hard to have all the sub-questions that are going to, directly elicit the information that might be included. And there's also some interesting literature just about the concept of legal narratives. And so, telling a legally cognizable, legally effective story is different than just telling something in more detail. So there's going to be, I think for us on the call that are legally trained or people that study the law know, there's people who are legally trained may know what facts are relevant and what facts to highlight and things like that. And so, we did kind of recognize this issue where people need to provide narratives or explanations and forms can be still quite difficult, even with all this help in a guided pathway if someone doesn't have a lawyer. We did find in some cases, even where this format allows for things like pop-up definitions and context, interpretation of legal terms still was hard. So people even sometimes looked at the hyperlink definitions and still had difficulty. So one example was prejudgment interest. And so I think Clio did a great job explaining that concept as much as they could in a pop-up window. That was still hard for a lot of people to understand what this concept meant. Things like arbitration, terms like that ended up still being difficult for some of the people that we were studying. And we talk about in the paper too, just the limits of using plain language in the legal context. So we saw this to be quite effective in certain contexts. For example, the PDF form refers to applicants and respondents. People had a hard time understanding what that meant. The guided pathway kind of instead said, put your information here and then put your partner's information here. People found that much easier. And that's a great example of using more plain language for people. But the term like arbitration, that's a term of art or a legally specific term. And so you can't always necessarily swap in different terms. And so even with pop-up definitions, there was some limitations that we saw. People found it to be a very lengthy process. And I think that's understandable. In a family law claim, depending on how complex the situation is, there's a lot of information it might need to provide. And we kind of also saw this as a barrier that guided pathways can help, of course, by making the form streamlined. There's only so much that can be done to kind of make it simpler. And also thinking about we have a quote in the paper from Shannon Salter and Darren Thompson, who you might know from BC. And they have a paper talking about kind of this tension where they say, designing justice processes to meet the needs of users isn't just a matter of making things as simple as possible, that there's naturally a degree of complexity when you're trying to solve complex issues. And so there's that tension there as well. You could make every process simple by flipping a coin, but that's not what we want to do in our justice system, right? So there is that kind of that tension. We kind of concluded maybe the best you can do is do what the guided pathways do by kind of setting expectations for users about how long this might take. I'm trying to help people make sure they have all the information as much as possible they need before they sit down and do the form. But that length is going to be kind of a hard barrier, at least unless we redesign family justice, which could also be really beneficial. But we're writing and thinking about the system we're in. So that's kind of one set of conclusions about how kind of establishing how this type of format can really help people, also looking at some of the remaining challenges, particularly in an area like family law. Another conclusion, part of what we were studying is, does this methodology of functional literacy that we saw to be so useful in evaluating paper-based court forms, is it also useful in looking at guided pathways? And we thought, again, quite clearly, it is useful. And certainly, Clio, when they did that initial part of the study where they looked to improve their guided pathways by using this framework, did think it was quite useful. To us, that's kind of a real world demonstration about how this methodology might be used by others thinking to design family law or design court form guided pathways. Again, some limitations here. Certainly, and I think this was emphasized early on by Jackie, this isn't a framework that's going to catch every single type of accessibility issue. It's just one tool that can look at certain types of cognitive complexity and suggest certain types of solutions. And so you're always going to want to be cognizant of other, types of barriers and think about how you might address those. So we acknowledge that. We did see both with this study and our previous study that it's not going to necessarily catch everything. When you actually do have people sit down and go through a PDF court form or go through a guided pathway, they may catch things that this framework doesn't catch kind of on its analytical application. And so kind of supplementing with human testing is going to be important and helpful. Jackie alluded to this before. I think one thing that was interesting to us, or at least something that we took quite seriously, is how do you do that robust human testing in an ethical way? And I think we, along with Clio, identified maybe the best subjects to be testing this form are the people actually in court using this form, like actual SRLs who have family law issues. But we did ultimately, certainly on I think our side, feel and worry about some of the ethical issues about doing this. And there's also some interesting writing about, randomized control testing in the justice sector that we looked at and took seriously. Because when you have actual users, of course, they have real life legal issues. And part of what we were doing in our study, our format is to say, let people go through these forms, this guided pathway, and see where they have areas of difficulty. And certainly if we were in a situation where we saw someone have difficulty and maybe even understand they're doing something wrong with the form, it's not that we can intervene and then help them correct that. And so what are the ethical issues involved with that? There may be ways you can get around this or mitigate that. Maybe you have actual legal, have someone go through the process and have a lawyer help them make the corrections afterwards. That wasn't something we had a budget for. Also, there's confidentiality issues. I'm a legal ethics professor, so I was thinking about this. If you have researchers that aren't legal counsel hearing all these things as someone's filling out a form, that generally wouldn't necessarily be seen as subject to solicitor-client privilege. So do you expose vulnerabilities there potentially? Very vulnerable people. And so, those were concerns for us. I think it'd be, interesting to see as people do more empirical research on, different access to justice interventions, how do they address some of these ethical issues? So I don't think we thought, it'd be impossible to use actual subjects, but we did think that was an area of complexity. We're pretty close to 40 minutes, so that's perfect timing for me to wrap up. Going forward, one thing you might want to look at if you're interested in this issue of online court form guided pathways, and I know AI is kind of the big topic du jour. Clio did release a white paper, say about a year ago, maybe it was in the fall, but a few months ago, in any case, I'm thinking about whether or not generative AI could be used in a very strategic way to maybe improve some of these guided pathways. And one thing they talk about in this discussion paper is, looking at our study that identified this creation of narratives or answering open-ended prompts as a particular area of difficulty, and thinking about how maybe generative AI can be used not to kind of fill out a court form start to finish, but maybe just with some particular tasks to help people. And I know they've been studying that and wanting to think about, can they do that in a responsible and effective way? And so that might be something to see, which I think will be interesting. And they're certainly better placed to give more details about that. But I wanted to flag that paper for people that are interested in it. Jackie, I've just spoken a lot about our study, not even asked if you've had any reflections to add to that, because I think we do have a bit of time if you wanted to add something.
I think you've done a great job covering it. I think coming around to generative AI is really interesting because Amy and I had quite a conversation yesterday about it. I think the whole thing worries me, but I think it's a tool that we need to look at using. No, and I don't have anything to add. Thank you.
Yeah, so that's at the end. I certainly welcome any questions, or if people have done their own studies of this type of thing and had used different techniques or have observations or have thought about some of these ethical issues. We're certainly interested to learn from you as well. So I'll mute myself and turn it over back to our host.
Great. Thank you. Thank you very much. Thank you both for a very interesting overview of the paper. The paper is also really rich from a methodological perspective. I'm very glad that I saw the paper, and I'm looking forward to the final version, the final publication, because it is really, the work is inspirational. And a lot of people in New Brunswick are thinking about this kind of studies, given that there's a modernization package that was approved very recently. So we will have a large scale 5 to 6 years reform, which was announced by the government very recently. And some of the questions that I have come from that. I want to add the link to the paper that I didn't before, and give a second to people to think about any questions or reactions. Otherwise, I can jump. I have 2 questions and a comment, but I would like to give the floor to our participants first, who might be a bit shy, so I could start. Okay, let me start with something that is important for New Brunswickers who might be listening or might be looking at the talk later. I have a practical question as to the timeline, that the timeline for your own research, but also how long was the review process that you discussed for Clio. That was not clear to me. I just wanted to also understand and see um, um, how quickly can we move from a um, newly introduced guided pathways system to some sort of a literacy or functional literacy review. Any advice that you might have? What is a realistic timeline from your perspective, when institutions like the one that you partner, or even courts are partnering with researchers to do to think about this kind of improvements? That's the first question.
I'll maybe make one initial comment on that. And part of this study also kind of got influenced by the onset of the pandemic, and that kind of influenced our ability to do some of the work, particularly with human subjects. But we did have, and some of this is detailed in the paper, maybe to some extent, but a lot of challenges with data gathering. And I think anybody doing this type of project might experiencing that. And so what are some of the challenges? And people maybe on this call work with data even more than I certainly do. The data is often, fairly unstructured and dirty. And so even the process of getting the data, first of all, getting the data in an appropriate anonymized format, everybody's comfortable with, making sure it gets clean and structured. We had a big issue thinking that the system may be collecting certain data points and it wasn't. And so I think one thing we talk about in the paper, which doesn't directly answer your question, but this kind of concept of evaluation by design. And so when designing these systems, sometimes they're designed by developers, of course, that are looking at efficacy from their point of view, but not necessarily thinking about, what does the institution or the justice system need to know about this process, and what data points should we be capturing? So for example, one thing we're hoping to be able to get is to know, at what question do people sometimes abandon the court form, or how long does it take them to answer different parts? And at the time we were studying, those things just weren't being captured by the system. And so that did limit our ability with that anonymized data portion to be able to collect it. And yeah, between that kind of the anonymization, which is essential. Again, probably if people are more technical on the call, they can, maybe different systems, anonymization by design, where you can set up things in different ways. Jackie, you're much more kind of on the data side of things. Did you want to add anything to that aspect of stuff?
I think I think those are both really good observations. And one of the things, so as a social scientist and someone who's done a lot of evaluation work, what I always learn inevitably if I'm doing one of these projects is that what I think from the outside as being simple is never simple when you're actually engaged in it. Data that I think are available or not available, data are not in the state that I think that they're in. I know we spend a very long time in sort of data discovery, figuring out, working really closely with the people who held the data at Clio and with our research assistants, going through and really understanding exactly what the data were that we had. I think the point that Amy's sort of raised there about this idea about if you want to engage in evaluation, the best time to think about that is before the system goes live. It's like, be engaged at the beginning and understand what questions you're going to be asking of the system, what questions you're going to be asking about the system. Make sure that you have the data that you need, or understand that you can't have it, because sometimes you just can't have data. But that I think is really important. And that I would also say, if you have the luxury of being engaged at that early stage, I have also learned through hard lessons that while I'm not in any way a proponent of sort of gratuitous data collection, I think we always have to be very careful and responsible about the data that we're collecting. At the same time, it's important to think forward about what might be useful. So more is better, too much is bad. It's kind of finding the balance there.
No, this makes a lot of sense, and there's this collect once, use multiple times principle with regard to and it makes tons of sense. And at some point, you will see that researchers will need access to the data, and it would be great to have thought about it from the beginning. Thank you, and let me see if there's any. Feel free to turn your camera on or add questions to the chat, whatever is more comfortable. As you were talking about the ways in which individuals were experiencing frustration and had the chance to talk about their challenges with you, I was thinking about contracts and how both parties that enter a contractual relationship have the incentive to improve the content and the form. And it seems to me that in the case of court forms, we have this imbalance of power that has to play some role in terms of incentives. So one thing that I'm trying to think about in my work is how can we involve institutions in this game of thinking about the user experience and whether the as it is, legacy systems don't really have the proper incentives to think about the user experience. I'm not sure if that's a question or kind of a train of thought that comes. I'm trying to see if this kind of work gives insight as to how do we overcome this incentives issue. Of course, there's the person-centered justice literature has done a great job in bringing the user experience to the forefront, but we might have institution. It seems to me that this is something that I'm always confronted with, and almost inevitably. Perhaps seeing it more when you see how funds are allocated. rather than how much people are really caring about the user experience. I think judges and court staff do care about user experience. Any thoughts on that? Oh, I'm sorry. And
Well, maybe, yeah, maybe I'll just, I think it's a question in chat. Maybe I'll start. I mean, I don't think I think that's an interesting and apt observation. I mean, I think if you want to speak in the language of the institutions, the language is efficiency.
mm,
And I think there's, to my mind, if you think about how many court forms get sent back and all the time being used, or, court cases adjourned because something's not pled properly, they don't have the right form. I think there's probably some clear connections you can make in that language of efficiencies to say, given that there's this many people self-represented, making things easier for them is going to make things easier and better for everyone else. And that actually gets translated into actual dollars. I think one thing interesting, and I'm not the best person to speak to about why this happened with these guided pathways, but there's certainly it's a initiative that's supported very directly by the Administrator of the Attorney General, but it's housed within a public legal education organization. And so maybe thinking also too about kind of the role of public legal organizations. They certainly need funding. A lot of that funding is governmental. But there's ways you can also kind of look outside some of the kind of inertia and incentives that are in the kind of traditional system, and can you have other partnerships that can help this? And I know that there are other jurisdictions that have guided pathways for different things, and it can often be the legal organization, the legal education organizations. I forget in New Brunswick the extent to which that sort of thing's happening, but I don't know if Jackie, you have any thoughts on that issue of incentives and money. It's always
I
money.
would have gone exactly where you went, which is to understand and express the value in terms of how the various stakeholders are interested. So really, efficiency is got to be a huge draw, because we can articulate very clearly the cost of the system of self-represented litigants who are having difficulty with being with effectively engaging with this complicated legal system. So it benefits everyone. It's kind of, it's interesting. I worked for a long time doing program evaluation. I worked in a hospital where we had a lot of, it was a spinal cord injury unit. And it's perfectly obvious as soon as you say it, but we talk about accommodations, and we talk about building physical structures that accommodate diverse needs and diverse physical needs. And if you spend any time at all doing that, you immediately understand that a space that is accessible to someone who is in a wheelchair, it turns out, is also more accessible to someone who isn't. And someone who's pushing their mother, as I was, in a wheelchair, it's more accessible to me. It's more accessible to everybody. So that one of the things I think we have to stop thinking about these kinds of interventions as being somehow remedial in addressing the needs of a particular group, and instead start to say, you know what, everybody will benefit from this. Everybody might not need it, or they might not know they need it, but everybody will benefit.
Yeah, that universal design literature and language for sure. Yeah.
yeah, absolutely. We have two questions on the chat in the chat. I'm going to read the two quickly so that I give both of you the chance to answer. Courts are often sensitive to not providing legal advice. Did you come across any pushback when preparing breaking down pathways into clear actions for users that you might be blurring the line into legal advice? And how do you handle this balance? And the second question is related, and they're wondering how you balance the perception of precision in technical terms with clear or plain language.
These are great questions. They just happen to be really hard ones. I mean, for the first one, I mean, we certainly, Clio was the organization involved with developing kind of the sub-questions. And that might be one reason why an organization doing this does want to be partner with the Administrator of the Attorney General in terms of ensuring there's comfort with what types of guidance is being provided. I think when you start thinking about generative AI, where you can maybe, I don't know if Cleo's talking about this, but you could probably get some kind of interactive advice at certain points of the court form. It'd be a question about reliability for sure, but then I think that issue of the line between legal information and legal advice is going to become, quite salient. And I think there's a whole conversation, I think, now that's happening, which is good, is do we have to rethink some of this stuff about unauthorized practice in a world of digital tools, and how do we think about that? Because I think our traditional ways of thinking about it. So people write on this haven't, I don't think anybody's got the right solution, but I think, honing in on that as being an issue is right. I think, one other thing that Jackie and I also thought about is to have a court form with one broad question and maybe a guided pathway that helpfully breaks things down into sub questions. But to what degree then is that crafting certain answers with the institution's own sense of what's relevant versus what the court form actually says. I mean, it's not to say I don't think the Clio forms are helpful, but there is to recognize that's an added intervention, I think, is right. And so how do we think about that added intervention? It gets tricky too, because the more you guide people without kind of an actual lawyer there, do you guide people in the right way? Thinking about, sometimes in filling out a court form, the goal isn't to provide as many details as possible, particularly if some details might be prejudicial and not necessary to include. That was one thing I thought about quite a bit. And so I'll just say, I mean, I don't think I have a satisfying answer, but I think it's a really important part of it. And part of it may be also just getting advice from lawyers about when you're designing out what's legal advice, legal information. Like, I don't know, Jackie, do you have any thoughts on that first one?
No, I think that really covers it. I think that's
I mean, the more helpful you are, the more you're kind of acting like a lawyer, I think is the answer. And then the more you might get into some of these challenges. And so I think there does have to be care, even providing definitions of terms, right? That can be challenging. And the related one about definitions of terms, I mean, I think it'd probably be interesting to get information from the people who are doing this, like the public legal or education organizations, but how they're thinking about that. I think it can be quite challenging, and that's something we do highlight, that at some point you just hit, in our view, kind of a wall, that if you are trying to make things simpler, then you're not actually capturing the nuance and information people need. And that's kind of a hard block. And it's not the same with everything. Like I think, again, that example I gave, there's no reason why the guided pathway had to say, put the respondent's information there. They could say, put your partner's or like former spouse's information. That's much helpful. But, prejudgment interest, arbitration, there's only so much you can do there. And Jackie, you have some interesting thoughts probably on that one as well.
Yeah, I definitely do. And I think it is incumbent on all of us to be alert to the ways in which we use language as a barrier. And I think we get wedded to a couple of things, our own particular terms, our own particular construction of concepts, and our own particular focus on precision. So because I've worked in the medical context, I think about that, like myocardial infarction, cardiac arrest. There's a whole bunch of different terms that to a physician would mean different things, imply different things. But if you're really talking to a patient about, well, what did you experience today? And if they're thinking about it in their terms, where they're responding, like, what do we have to do? A heart attack covers it. And so I think what we have to be aware of and attuned to is the possibility that we're committed to language and complex language just because we always have been committed to that complex language, and that sometimes we can let go of some of that precision. And I can point to academics way more than lawyers here, that we're committed to a kind of precision that we don't actually need to be committed to, that in the context it's not actually required. And I think that's hard to see, but really important to see.
Yeah, that's a fair point. I was thinking about the complexity that a second language in a bilingual jurisdiction, or if you start thinking about language needs of different individuals bring, and it makes it even more. It makes the argument for plain language even more compelling. With that, we are on time, and I would like to thank everyone for joining. Thank you very much, Amy. Thank you, Jackie, for this presentation, the wonderful presentation, and for answering our questions. This was very helpful, and I wish everyone a great rest of your day, afternoon, depending on your time zone. And thank you.
Thanks so much for the invitation.
Thank you very much. I look forward to hearing developments in New Brunswick. Absolutely. Yeah.
Yeah.
Take care, everyone. Thanks for coming.
Okay.
Bye-bye.
Bye-bye.